Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today we're talking about civil forfeiture. Cases that should have gone to the Supreme Court of Canada, but didn't. In British Columbia, the BC government used its civil forfeiture powers against the Hells Angels to try and seize a number of Hells Angels clubhouses and other belongings belonging to the Hells Angels Motorcycle Club. As a result of these seizures, the Hells Angels brought a challenge to the decision to require forfeiture of all of this information. As a result of these seizures, the Hells Angels brought a challenge to the laws that permitted the British Columbia government to seize their assets, arguing that the laws were outside the jurisdiction of the province, specifically by saying that the province didn't have the power to regulate future potential criminal activity, that this was only solely within the power of the federal government. Under the Canadian Constitution, criminal law is exclusively reserved for the federal government to regulate. And so if the provincial government is impermissibly regulating by essentially creating laws that affect future criminal activity, they are stepping into the role of the federal government. This was the argument that was advanced. The Hells Angels were somewhat successful, and then their decision was overturned by the Court of Appeal, and leave to appeal was denied by the Supreme Court of Canada. But this case raises important issues, because as we see, especially from our neighbors down south, the use of civil forfeiture laws is becoming all the more significant in not only a mechanism to better equip government with assets that it can then sell and use for financial benefit, including equipping the police with more money and more funding, but also civil forfeiture laws are used as a replacement for criminal law. Essentially, where it might be too difficult or too complex or too time-consuming or too costly to pursue and continue a criminal investigation and prosecution, instead, a government may use its civil forfeiture powers to essentially seize the assets that it believes are involved in criminality and thrust the burden back on the person whose assets were seized to try and prove that they weren't used for criminal activity or weren't obtained by criminal activity. It is essentially a crime prevention method. But that's what the Supreme Court of Canada ought to have decided, the extent to which civil forfeiture laws can go in being used to prevent crime and essentially to insulate the government from having to properly prosecute and investigate crime. The rules that apply in civil forfeiture proceedings are very different than the rules that apply in a criminal proceeding. It's a relaxed standard that the government has to meet. There are relaxed rules in relation to procedural requirements. And because the government gets to write the laws, the government can change the laws at will in order to make the regime comply with what they intend to do. This ultimately sets up a system where people are effectively given quasi-criminal penalties through a provincial administrative scheme that puts the burden again on them to take action against a seizure that has already been effected against them, while they may have limited access to resources that they might need to fund those challenges. This is an unfortunate way of controlling criminal activity because it limits and necessarily constrains the application of constitutional rights, which is why the federal government should have jurisdiction over criminal law powers. Unfortunately, the Supreme Court of Canada may have missed the mark in the overuse and overbreadth of civil forfeiture proceedings and where they are trending, not only in the United States, but also now in Canada. Hopefully there's another case where the Supreme Court of Canada has the opportunity to consider the significance of civil forfeiture proceedings and takes the opportunity to consider the extent to which the government can rely on these laws to control criminal activity as opposed to simply prevent people from profiting from having used criminal activity to get gains. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada but Didn't. I'm Kyla Lee at Acumen Law. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.